Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and I will be taking you through the significant orders and judgments passed by various courts in the country and some important international news from this week. Let's begin with Supreme Court this week. The Supreme Court has said that the Aligarh Muslim University, AMU, holds the status of an institute of national importance, questioning the significance of whether it is classified as a minority institution or not. The court stated that the intent of Article 30 of the Constitution is not to ghettoize the minority, addressing the right of the minorities to establish and administer educational institutions. A five-judge constitution bench previously held in S. Aziz Basha versus Union of India case in 1967 that a central university, AMU, cannot be considered a minority institution. The Center Admission has said that the minority educational institutions are not required to implement the reservation policy under Section 3 of the Central Educational Institute Reservation and Admission Act 2006, as amended in 2012. Refusing to stay the new law adopted for the appointment of the Chief Selection Commissioners, CECs, and Election Commissioners, ECs, by a panel, the Supreme Court has issued notice to the Centre regarding a batch of petitions challenging a new law. However, a bench of Justice Sanjeev Khanna and Justice Dipankar Datta agreed to examine the petitions. The bench has asked senior advocate Vikas Singh, appearing for Congress leader Jaya Thakur, who sought a stay on the new law, to serve a copy of the petition to the Centre's counsel. The Supreme Court, while stressing the importance of judicial discipline, has directed the High Courts to strictly adhere to the doctrine of merger, which clearly states that there cannot be at the same time more than one operative order governing the same subject matter. The division bench of Justice Vikram Nath and Justice Rajesh Bindal, while adjudicating upon an appeal, observed that when a decision of a coordinate bench of the same High Court is brought to the notice of the bench, it is to be respected and is a binding subject to the right to the bench of such co-equal quorum to take a different view and refer the question to a larger bench. The Supreme Court has directed the Union government to frame a national policy to phase out heavy-duty diesel vehicles like trucks and trailers and replace them with BS6 vehicles that use cleaner fuels, underlining people living in all parts of the country and not only those living in the Delhi NCR, National Capital Region, are entitled to breathe clean air and a pollution-free environment. Deciding to monitor the government's steps regarding the proposed policy, a bench of Justice A.S. Oka and Justice Pankaj Mittal remained emphatic that air pollution directly affects the fundamental rights of all the citizens guaranteed under Article 21 of the Constitution, and that the enforcement of this right is not confined to the people living in Delhi NCR. Now let's have an overview of High Courts. The Delhi High Court, while sentencing a lawyer to 6 months in jail for contempt over scandalous, unwarranted and baseless imputations against High Court and District Court judges, observed that vilification of judges can affect the administration of justice as it becomes a form of public mischief. A division bench of Justice Suresh Kumar Kair and Justice Shailinder Kaur opined that the judiciary is not immune from criticism, but when the criticism is based on distorted facts or gross misrepresentation of material avertments to intentionally lower the dignity and respect of the court, it must be taken cognizance of. The court was of the view that for a healthy democracy, there must be an impartial judiciary. However, it cannot be impaired by vindictive criticism. The Himachal Pradesh High Court has observed that a partner of the firm cannot be charged with a criminal breach of trust of the property of the firm. The court, while allowing a petition filed for seeking pre-arrest bail, said that the offences punishable under Section 406 and 420 of the IPC cannot be tried together, as both these offences require different mens rea. The Andhra Pradesh High Court, while dismissing a petition that challenged the judgment in which a suit for declaration and perpetual injunction was dismissed, ruled that the plaintiff's prolonged silence of 22 years and implausible explanations regarding obtaining a copy in 2017 undermined his claim that the General Power of Attorney (GPA) was executed involuntarily, and since he did not seek to declare in null and void earlier, he cannot now succeed in obtaining a declaration of title based on a discretionary relief. The court held that when the evidence on record reveals that the plaintiff miserably failed to probabilize his contention that GPA was vitiated as it was not executed voluntarily, he cannot support his contention based on the so-called discrepancy between the evidence as the matter in which the consideration was paid. The relief of declaration sought by the plaintiff is a discretionary one. The Karnataka High Court has observed that writ court cannot be approached to grant relief based on an anticipatory breach of a contract. The court disposed of a writ petition filed under Article 226 and 227 of the Constitution of India, praying for directions to issue the necessary order or notification bringing into the knowledge of all the MLAs and politicians in the state not to interfere in any manner with the functioning of any executive or administrative bodies, including municipal corporations. Note, to pressurize them to work in a particular manner or to do a certain thing in a manner not known to law, and not to seek favors from any service provider or contractor or to threaten them in any adverse consequences. The Punjab and Haryana High Court, while dismissing an appeal filed by the husband raising objections to the wife's affidavit of evidence, observed that a family court can take any material into evidence for effective adjudication whether it fulfills the requirement of the Indian Evidence Act or not, and further ordered 8 Rule 1A CPC of 1908 is not a mandatory provision, and rather it is a directive in nature only, specially with respect to the proceedings under Family Court Act. The court observed that under Section 10(1) of the Family Court Act empowers a family court to be a civil court for the purpose of exercising all powers vested in a civil court, and the provisions of CPC have been made applicable to the proceedings before the family court, but at the same time has been expressly stipulated in Section 10(1) of the Act itself that such application of CPC shall be subject to other provisions of the Act and the rules. The Patna High Court has held that the son cannot claim a right to residence in a building exclusively owned by the father by virtue of the relationship alone. It was furthermore observed that given that the claim does not fall under Section 23, no eviction may be issued under Senior Citizens Act. In the claim before the tribunal and under the Senior Citizens Act, it has been stated that only the right of maintenance from property may be enforced provided it comes under Section 23(2) of the Act. A permitted or encroaching occupation would give the appearance of a transfer, which would absolve the property owner of their need to maintain the property through rental money from the occupied rooms in the rest house. Moving on to international news this week. South Africa has launched a landmark case at the top UN court accusing Israel of breaching the UN Genocide Convention, and argued that even the deadly October 7 Hamas attack could not justify such alleged action. According to a report, Pretoria has lodged an urgent appeal at the International Court of Justice to force Israel to immediately suspend its military operations in Gaza. The US Supreme Court has denied a bid by Intel and Edwards Lifesciences to revive part of their lawsuit challenging a US Patent and Trademark Office policy that reduced the numbers of patents and the federal agency reviews. The justices turned away the appeal by the companies of a lower court's ruling dismissing their challenge. Intel and Edwards told the Supreme Court that letting the decision stand would give the office free rein to adopt standards that undermine the patent system with no judicial oversight. The Supreme Court has also rejected previous requests by Intel, Apple, and Vitaris-owned generic drug maker Mylan to review the Patent Office's policy. The Supreme Court of Pakistan has ended the lifetime disqualification of lawmakers, recalling its earlier order of debarring politicians from running the office ever. The decision has come as a major boost for several big names who are aiming to contest the general elections. The latest judgment allows PML Supremo Nawaz Sharif and IPP Chief Jahangir Tareen to run for office as they were disqualified for the life. The Supreme Court declared that no person can be barred for a lifetime from running in elections if they are disqualified under Article 62(1)(f), setting aside its landmark judgment in the Saimulu Baloch case. In the end, we have miscellaneous news. Former Chief Justice of India, Justice UU Lalit, has said that the LGBTQ community, in his view, is not entitled to claim vertical sort of constitutional reservations like those given in to the scheduled caste, scheduled tribes, and other backward classes or economically weaker sections. However, he said that the group might claim horizontal reservation status along the lines of the ones for women and disabled people. The Delhi High Court has directed that e-filing be made mandatory in both civil jurisdictions and criminal complaint cases before the district courts. A revision bench comprising of Acting Chief Justice Manmohan and Justice Manmeet Preetham Singh Arora observed that it is in the interest of all the stakeholders that e-filing process is made robust in the district judiciary so that parties as well as advocates can easily avail the facility of filing pleadings, documents, and interim application online. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.